Time for some legal talk that affects us all. I believe America's future rests in the hands of the judiciary, and we are about to find out exactly what that means. The U.S. Supreme Court is currently deciding a number of major cases that could fundamentally reshape the balance of power in this country, and the stakes couldn't be higher. A series of cases now before the court could decide what American life feels like for the foreseeable future, and they all have the power to potentially reshape how we live. First up, redistricting. In Louisiana versus Calais, the High Court is taking up a challenge that could eliminate one of the last remaining protections against efforts to dilute the voting power of Black and Latino communities. At stake, whether voters choose their representatives or politicians choose their voters. At issue is Section 2 of the Voting Rights Act, and that provision, which has long required states to draw districts giving minority voters a fair shot at electing candidates of their choice. Louisiana Republicans are asking the court to scale that back, and a ruling in their favor could reshape congressional maps across the country before midterm elections. Next on the docket, birthright citizenship, the constitutional guarantee under the 14th Amendment that grants citizenship to all persons born in the United States. Now, historically, this amendment, along with the 14th and 15th Amendments, were known as the Reconstruction Amendments, and they were intended to fully incorporate former enslaved Blacks as citizens in American society. Legal experts, like my next guest, warn that if the court opens the door, even slightly, it could destabilize a principle that has been settled law for over a century. Next up, the firing of federal officials in Trump v. Slaughter and Trump v. Cook, which are cases involving Federal Reserve Governor Lisa Cook and Federal Trade Commissioner Rebecca Slaughter. The court will decide whether the president can fire independent officials at will. The stakes are more than just procedural. This case could upend the Federal Reserve and other independent agencies that have been traditionally shielded from politics. Also on this very important docket, Watson versus RNC, or the case of mail-in ballots. Specifically, whether ballots that are mailed in on time but arrive after Election Day can be counted in election tallies and decide tight races. And finally, a major campaign finance case to keep your eyes on: the National Republican Senatorial Committee versus the Federal Election Commission. At stake is how much national parties can spend in coordination with their candidates and whether caps on spending should exist at all. At a time when wealth already dominates our politics, a ruling like this could pour even more fuel on campaign spending. Joining me now are two law professors. Joining me now are two law professors and co-hosts of the Strict Scrutiny podcast, Leah Littman and Kate Shaw. Thank you both for being here. Leah, I want to start with you. The role of the Supreme Court, by way of the Constitution, is essentially to interpret the law. But it seems like the SCOTUS is really not being bashful about attempting to essentially write law in pursuit of a project. Looking at the docket, taking off my glasses so I can talk to two lawyers, what is the through line here?
I think the through line is really the Supreme Court's power to broadly refashion how our constitutional democracy works. As you were suggesting, when the Constitution was originally created, the Supreme Court was a much more modest institution. For the first 100 or so years of the Supreme Court, the Supreme Court struck down only a handful of federal statutes, and it basically described its authority as trying to effectuate and implement Congress's will. That is not what this Supreme Court does. Instead, it is getting ready to take a slash and burn approach to major federal laws, like the Voting Rights Act, to potentially upend how our elections are conducted. In the Watson absentee ballot case that you noted, we are already living through and seeing so much of what the Supreme Court has done to our democracy with the partisan gerrymandering wars that they've enabled. And this court is not done yet.
Okay, I really want to appreciate the conversation about the VRA that Leah just brought up. And as a civil rights attorney, I'm going to stay there. Let's go to Louisiana and talk about this Calais case and how big its implications are, particularly when we talk about the way that enforcement of the VRA has been curtailed by other rulings with this court. Can you make it plain for our audience what's at stake here?
Sure. So the 1965 Voting Rights Act is one of the single most important legislative achievements Congress has ever made. It fundamentally reshaped aspects of American democracy, making real the promise of both the 14th and in particular the 15th Amendment, which guarantees the right to vote regardless of race. So until the Voting Rights Act, we actually didn't meaningfully have a multiracial democracy in many respects. After the VRA, we did for a time, and the Supreme Court has essentially dismantled one of the key provisions of the Voting Rights Act. That's back in 2013 when the court struck down the pre-clearance regime of the Voting Rights Act, which required states with particularly egregious histories of racial discrimination in voting to get federal approval before changing anything with respect to voting and elections. But back in 2013, when the court struck down that key provision, they said, don't worry, Section 2 of the Voting Rights Act, a separate provision that bars racial discrimination in voting, continues to implement the kind of goals of the Voting Rights Act and the 15th Amendment. And we are now in 2026, I think, on the cusp of the Supreme Court either severely curtailing or maybe eliminating entirely that last key vestige of the Voting Rights Act. And depending on when they do it, it could really upend the November midterm elections if the court doesn't do something to essentially pause the implementation of its ruling. It could throw into question legislative district lines, not only in Louisiana, where the case arose, but in a number of other states with this critical midterm election looming.
You know, Kate, I really appreciate the historical context that you gave there to the VRA in terms of its history and being a cornerstone of allowing access to full democracy or more democratic rights, and looking historically at those Reconstruction amendments that I talked about, the 13th Amendment, the 14th Amendment, the 15th Amendment. It does not appear as though the administration is going to get its wishes with respect to the birthright citizenship issue. But Leah, can you talk a little bit about, even if they are not able to overturn the 14th Amendment, even if they lose the birthright citizenship case, how much damage can still be done without having to invalidate any of those Reconstruction amendments that we've been talking about?
So I think it's important to think about this both in terms of the birthright citizenship case itself, as well as the other cases that we've been talking about. So on the birthright citizenship matter in particular, even if the Supreme Court rules against the administration and concludes that the executive order is plainly inconsistent with the Constitution's guarantee of birthright citizenship, the administration will have succeeded in kind of injecting this issue of birthright citizenship into public discourse and creating real uncertainty about it. It will have produced some unsettlement of this key foundation of our constitutional order that has existed for more than a century. So let's say one Supreme Court justice or even zero Supreme Court justices end up casting their vote with the administration. They have still allowed the country to engage in this more than year-long debate about whether birthright citizenship exists and who it actually protects when the Constitution is quite clear. And the Supreme Court, even if it forces the 14th Amendment in the birthright citizenship case, could very well dismantle or effectively nullify so much of the dream and promise of Reconstruction if it dismantles what remains of the Voting Rights Act. As Kate noted, the Voting Rights Act is really what made this country into a multiracial democracy of the kind that Reconstruction envisioned. If the court takes away the legal protections for the political opportunities for minority voters, it will be sending us back to a time when state legislatures wrote rules that effectively locked white voters and white political officials into power. And by doing that, the Supreme Court would be undermining, if not nullifying, a lot of the promise of Reconstruction, even if it upholds the principle of birthright citizenship.
Undermining, if not nullifying, I think is a really important segue to the conversation that I want to have with you, Kate, about these sort of emergency shadow docket, emergency shadow opinions. They're not necessarily brief. They're not reasoned. There's no real opinion that's given to them. And we've seen this court begin to use that more and more with this administration. It's hard to think, or not to think rather, that this is somewhat of a siphoning away of power being given to the executive branch by the court that no one seems to want to own. Am I seeing that right? And if not, what is the other way to actually interpret that?
I think that is the right way to see it. This is what the court has done in the last year and change on the shadow docket, has been to effect a large-scale transfer of power to the president and away in many instances from Congress and away from independent agencies. And the court has done it in a way that evades a lot of public scrutiny and debate and criticism of the sort that the cases on the court's ordinary merits docket typically get. So birthright citizenship, the Voting Rights Act, there's a lot of public debate about what the court is thinking, what it's been told, what it might do in those really critically important cases. There is much less attention paid to matters that come to the court on the shadow docket. These are emergency petitions. The orders rather are often issued in the dead of night, sometimes without any legal reasoning whatsoever to justify the bottom line conclusion. And so they're not subject to the same kind of scrutiny. And I think that's incredibly dangerous because they're in many ways every bit as important as the cases the court hears on its merits docket. And in those cases, the shadow docket cases, over 24 times the court has handed down rulings in favor of the Trump administration, and sometimes it's extravagant assertions of executive authority, and it has blessed really unprecedented actions to do things like dismantle foreign aid, allow the president to kick out trans service members from the military, to dismantle essentially public federal agencies like the Department of Education, to allow immigration officials to send to third countries individuals with no relationships with those countries, to cancel temporary protected status for hundreds of thousands of individuals. So the list is very long. And I think that quietly and in the background and outside of, again, a lot of public scrutiny, the court has fundamentally changed the allocation of power between the president and Congress and has asserted for itself extraordinary power that I think is damaging and destructive to a healthy system of separated powers and American democracy. We learned a good amount last weekend when the New York Times broke this really important story about what went on behind the scenes in 2016 when the court stayed the Obama administration's Clean Power Plan. And we saw then the court evaluating very differently the interests at stake than we are, I think, appearing to see in the more recent shadow docket orders again and again in favor of the Trump administration that without explanation side with the presidency and presidential power.